Hi, good morning, everybody, and welcome to our PBBIC Hot Topic webinar. My name is Crystal Bise, and I'll be your host today. And in today's session, I did want to let you know that we will be recording our webinar, and we'll be sending that out to everybody who is registered, so you don't have to worry. We will send that out to you with the PowerPoint slides, so you can make reference back and forth and review what you've learned today. If you have any questions during the session, you can go ahead and type that into the Q&A box. I'm sorry, we will not be recognizing raised hands. We will be taking your questions just in the chat or the Q&A, best in the Q&A box though. So if you have any questions along the way, go ahead and drop them in. At the end of the session, we will have an evaluation pop up. So if you could take a minute to just go ahead and give us your input on how we did. And if you have any topics for future sessions for us, we would like to know, and your opinion is very important to us. I do wanted to mention that we have one very, very exciting event coming up. And that is on September 28th, and you think, oh, that's so long, but before you know it, September 28th is going to be here. And it is called Trending Up, Riding the Wave of Success, and we will be featuring 3 great, awesome speakers. First, we have Mike Lee. He is our peak performance expert. We also have Beth V, and she's our nerdy best friend, and many of you know her, have heard her. She's going to give you the latest tips on AI, ChatGPT, and other nerdy information. And of course, we have Lee Brown, our realtor, our coach, our author. She's going to just set the tone for riding the wave. So you don't want to miss that. There's more information coming, so don't worry. We will make sure that you have every opportunity to register. So at this time, I'd like to have Wendy pull up Kalama Kim. He is our president of Hawaii Realtors, and he will be introducing our speaker, Diane Mosley. Wendy?
Aloha. Thank you for making the time to attend this webinar and session. I know how busy you principal brokers and brokers in charge are. Things are coming at you all the time, and that's why this topic for today's seminar is appropriate for all of you. And that topic is empowering members, uncovering the benefits of dispute resolution. And your instructor, Diane Mosley, she has got so much experience in this area. I want to read some of her bio for you. Diane Mosley joined the staff of the National Association of Realtors in 1990. Prior to that, Diane was affiliated with the Honolulu Board of Realtors and the Hawaii Association of Realtors for 5 years as a professional standards administrator. I bet they're in that same building on 12th Ave back then. During her tenure with the National Association, Diane has conducted numerous outreach programs for professional standards training. She has a major responsibility for National Association's mediation training seminar. She is responsible for updating all professional standard policy manuals, oh my goodness, and materials on an annual basis to reflect current policies and procedures. Now, as principal brokers and brokers in charge, I'm sure you've seen a lot of manuals and all these that we're talking about in her bio, and you appreciate that she's part of this. She received her Bachelor's of Arts degree from the University of Wisconsin, Eau Claire, hope I pronounced that right, and a master's in counseling from the Illinois School of Professional Psychology. Please have a good time, enjoy, absorb this information from our very well qualified instructor, Diane Mosley. Thank you, Diane.
Thank you, Kamala. Much appreciated. I understand that you're traveling today, so can't be with us, but we much appreciate your leadership for sure. Absolutely. So without a further ado, I want to share my screen, and can you see that, Crystal?
Yes.
Perfect. I worked with Crystal and Ethel way back in the day. Ron Chang, those of you who are veterans, Ron Chang and Kamala's right. We were on Ward Avenue, I think it was, we shared staff, right? The Hawaii Association shared staff with the Honolulu Board. So, Ethel and Crystal and I go way back. Ellen Kanashigi was with us way back in the day. I remember how close Ellen and Marcus Nishikawa were. I miss my friends there in Hawaii for sure. I wish I could be there in person, but this is the next best thing, of course. So glad to be here to empower you and help make you and your licensees most successful. That's what we're all about. Local board, the state association, and the National Association. We're here to serve you. And the purpose of today is to give you a 10,000 foot overview of 3 important dispute resolution tools, benefits that you have at your disposal. We're going to initially do a poll. There's only 5 questions, and we'll work through that poll. Any questions that you have, again, use the Q&A as Crystal said, or the chat. Then we're going to talk about dispute resolution chunked into 3 different categories. The first will be arbitration. The second will be the ombudsman program that your associations offer. And then the third, mediation. And I'll draw some similarities and distinctions. And at the end of the day, the end of the top of the next hour, prior to that, I'm going to share some tips with you where I've seen other brokers perhaps make some mistakes, right? So to help your office function as efficiently, right, as it can, we want to share that information with you as well. So anytime at all, populate that chat. I'll be queuing. I don't know if it's going to be Wendy or Ethel who will be looking at that chat and Q&A to make sure that we're catching as many of the questions as we can. Just given the next, 50 odd minutes, we might not get to all of them. If not, perhaps I can relay those answers in a different format. And who knows, if we finish early, that's great too. You can always get a few extra minutes back into your day. We'll hopefully have a little extra time at the end to ask any question that you might have with respect to professional standards, even if it's not on this particular topic, dispute resolution. So with that, what I'd like to do is, if I can, there we go. Crystal, well, I should ask first, are there any questions about how we're going to spend the next, 50 odd minutes? Are we all good to go?
No questions, Diane.
Super. All right. Well, again, as Kamala said, thank you for joining us today. I know everyone's schedule is extremely busy. So this is being recorded. So what I'm going to do is read the question, because the polls, I don't think when there's a recording show. So I'm going to read this for others who might, view this at a later time. The first question is, the person who writes the successful offer is the procuring cause of sale and entitled to be paid by the listing broker. So I see maybe, yeah, weigh in. What do you think? Still fluctuating just a tad bit. I'll wait until they calm down a little bit. I can Crystal see those polls? Yeah, they're slowing down a bit. So about 20% of you, 18, well, 19, well, 17%. Okay, yeah, no, back up to 19. So yeah, 20. So 20% of you said yes, right? 14% of you said no. And the vast majority of you, right around 66%, said maybe. So let me debrief this poll before we go on to the next one, right? Those of you who said maybe are spot on. And I'm going to explain the reason why when we get into more of the arbitration information. But I will mention here, and you'll hear me say it again, because it's not always commonly understood, and almost 21% of you, as far as this poll is concerned, thought that that was true. Yes, that's who gets paid, not necessarily. And the reason why this is an important webinar is so that you are the most well-informed, and you can tell your licensee when they come in and say, oh, I wrote the offer, so of course we're going to get the money. Well, maybe not, all right? Because those arbitration hearing panels, there's no one predeterminer as to who's entitled to what amount of money is on the table, right? That arbitration hearing panel is going to take into consideration a plethora of factors for consideration. They're going to, look at the entire course of events. So granted, that will be an important component or a factor to consider, as will if there's an agency relationship, as will who showed the property, but there's no one determining factor. And that's the reason why the best answer for this one is maybe. All right. All right. How about you launch the next one, Crystal? And remember, if you've got any questions, just throw them in that Q&A. I think Crystal said she'd prefer. All right, so the second one, a listing broker has an exclusive right to sell with a seller, which does not sell. Listing broker 2 is going to pick up that listing, enters into an exclusive right to sell with the same seller, and the property closes while listed with listing broker number 2. If listing broker 1 requests arbitration over the listing broker's portion of the commission with listing broker 2, what do you think the grievance committee is likely to do with that? So we've got listing broker 1 files against listing broker number 2 where the property closed, and listing broker 1 is saying, hey, I want the listing broker's portion of that commission. What do you think that grievance committee is going to do? We've got a realtor principal affiliated with one firm and a realtor principal affiliated with another firm. And the choices that you have for those who are watching this recorded are dismiss it as not arbitrable, refer the arbitration for mandatory arbitration, and then the third involving the realtor principals of the respective firms. And then the third answer or option that you have is the answer will depend on other factors currently not known. I'm so glad I used, I've seen this happen, and I'm so glad that we've had this opportunity. 7% of you chose the first option, that likely the grievance committee would dismiss this as not arbitrable. And I'll explain what I mean by that word. It's an odd word, and I'll explain it in just a moment. So that was only 7% of you chose that option. I see 16% of you chose the second option, refer it for a mandatory arbitration. And then the test takers, right, chose the maybe answer. The answer will depend on other factors. Almost 80% of you said that. Almost 79% of you said that. The best answer here is dismiss it. And let me explain the reason why. The first option, only 7%, 6% chose that first option. So there's some misunderstanding, although it's crystal clear, I think, in most PBBIC's minds that arbitration is between realtor principals associated with different firms, right? That is, I think, very, very well understood. But the grievance committee has to peel back the layers of the onion and not just look at the structure of what's filed, right? Realtor principal company A versus realtor principal company B, and they're beefing over commission, right? But they got to look at what commission they're looking for and whether or not there is a basis upon which to render the award. In this instance, you've got 2 listing brokers, right, working with the same seller. And the complainant in this instance is asking for the commission from the successful listing broker with respect to the listing broker's portion of the commission. Look, I had the listing first. I should be the one that's paid, right? That is not an arbitrable issue. And when I say arbitrable, what I'm talking about is a contractual relationship as outlined under Article 17, or a specific non-contractual relationship, which we address under Standard Practice 17-4. So when you look at this dynamic, listing broker 1 wants money, right, from listing broker number 2. Listing broker number 2, there's no contractual basis to render the award because listing broker number 2 never offered listing broker 1 any monies. The remedy that listing broker 1 has, right, who do they have that contractual relationship with or previous? That seller. So if listing broker number 1 thinks that they're entitled, given their listing agreement, to be paid, who do they go after? Not listing broker number 2. They file directly against their seller. All right. Best answer for number 2, poll number 2, is the grievance committee will likely dismiss that arbitration request. All
Diane?
right.
Diane, here's a comment. Said you did not say the listing number 1 had expired or been canceled.
And yes, my bad. Yeah, so the teaching point here is yeah, I assumed that, and of course, you know what they say about that. But yeah, there's no Article 16 going on here.
Okay.
Yeah, no Article 16. Those of you that are familiar with Article 16, you know, there's a ethical principle that you take no action inconsistent with another realtor's exclusive agency, right? So, so that wasn't in play on this one. I should have made it clear that listing broker number 1's listing expired without it selling. So thank you, Ethel.
Here's another one. So suppose listing broker number 2 sold to a client listing broker number 1 previously showed during protection period.
Yeah, right. And again, whether or not that listing broker number 1 is entitled to be paid, given their contract, they got to go after the seller though. That would be where their recourse, their redress would be with the seller. That's where that contractual relationship falls. There is no contractual relationship between listing broker number 1 and listing broker number 2. But that's a good question with respect to protection clauses, because those are pretty common, right?
Okie dokie, then we can go on to the next one.
Yeah, I think so. Let's launch number 3, Crystal, if we could. So the third one, we've got a member of the public. The question is, a member of the public can invoke mandatory arbitration with the realtor they are working with. So is that true, false, or it depends? A member of the public can invoke mandatory arbitration with the realtor they are working with, their broker principal, the PBBIC, right? There's a big split with this one too. So we picked good questions, Crystal and Ethel and Wendy. And it's calmed down. I see. So the first option was true, and about 31% of you chose, 32% of you chose true. About 28% of you said, 38, my bad, 38% of you said false, and 30%, the minority chunk, so it's almost a third, says it depends. Those of you who chose the latter, the last, it depends, are correct. And let me explain what I mean. So those of you who picked true probably had in your mind that I was talking about a client, someone who you have a relationship with, a contractual relationship with a client, right? Be it either a buyer or a seller or a tenant, or I mean, a landlord. You know, if you're working with a owner of property, and that is arbitral. Those, when a client invokes arbitration, up to the grievance committee, depending on what the client is asking for, of course. But from a structural perspective, when you look at Article 17, yes, a client can invoke mandatory arbitration. Those of you who have a copy of the Code of Ethics and Arbitration Manual that includes our procedures will note that in Section 44, we talk about 2 mandatory types of scenarios for arbitration and 3 voluntary ones. And the distinction that I wanted to draw here with this third question is there's a difference between a client and a customer. A customer is someone, and a customer who requests arbitration, it's not mandatory with respect to the broker principal. So say, let's say, for example, a tenant, you know, somebody doesn't, they bust up the walls or whatever. And so you as the property manager don't refund that $1,000 security deposit. And the customer, the tenant, gets sideways and requests arbitration with you, you as a broker principal do not have to arbitrate that. Conversely though, right, if your client, someone who does have a contractual relationship with you, invokes arbitration, you would have a responsibility, assuming the grievance committee refers it on out, as otherwise arbitrable, timely filed, things along those lines, to arbitrate with your client. So it depends on the status of that member of the public as to whether or not arbitration would be classified as mandatory or voluntary. Ethel, you see any questions on that one?
No questions.
Cool deal. All right, Krista, let's go with number 4. There's only 5 of these, so we're almost done. So number 4, if cooperating broker A is not paid by the listing broker and cooperating broker A files an arbitration request against the listing broker, but the listing broker has already paid out that cooperating broker's portion of commission that they've offered to cooperating broker number B, what can the listing broker do? What choices does that listing broker have? So the first choice is they can inform cooperating broker A, the listing broker can inform cooperating broker A that they can instead file the arbitration request directly against cooperating broker B. That's the first option. The second one is the listing broker can file an arbitration request against cooperating broker B directly without naming the listing broker. So cooperating broker A could file directly against cooperating broker B who was paid. Or the third option, call the association and ask for mediation. Just waiting for the numbers to calm down here. So, and then they're pretty quiet. So you're almost evenly split with respect to A and B. You're both at about 15%. The vast majority of you, about 65%, chose option C, call the association and ask for mediation. All 3 of these answers are viable. The teaching point that I want to make here, though, that's what your association is there for. I mean, you pay those dues every single year, and we deliver providing those benefits and those services. And, the duty to arbitrate, yeah, it's a duty, but it's also a huge privilege as it is to invoke mediation. So if mediation doesn't work, though, right, how do you, as a listing broker, protect yourself in an instance where you've already paid the money out and cooperating broker A that you didn't know about files arbitration against you? The best way for you to protect yourself is to, certainly you can tell them, hey, under standard of practice 17.4, the first paragraph, you can, cooperating broker A, file directly against cooperating broker B, right, who was paid. That is a non-contractual issue that would be classified as mandatory. Even though it's like I said, a non-contractual issue, that's an option. So those of you who chose A are okay with that. But if that cooperating broker A doesn't withdraw their arbitration request against the listing broker and chase the money, file against cooperating broker B, then how do you, as the listing broker, protect yourself? You're going to choose option B. You're going, because you already paid out, to a cooperating broker. You offered a particular amount of money and you paid that, right, when the property closed. So to protect yourself in the instance where a arbitration hearing panel might side with cooperating broker A that you should have paid him or her, the best way for you to protect yourself is to enjoin, file an arbitration request against the cooperating broker that you paid. That gives the arbitration hearing panel the ability to make it so that you don't work for free. If you see my point, if they award that cooperating broker's portion of the commission to cooperating broker A who wasn't paid, and you don't enjoin the cooperating broker that was paid, if you don't file against them, you could be working for free. So any of these 3 options are workable in this question number 4. So Ethel, do you see anything pop up on this one?
Yes, in what scenario would there be 2 viable co-ops?
Yeah, So maybe not in Hawaii, but it is quite common. The most, I think the most common type of arbitration is procuring cause, and we're going to talk about that. So let's say I'm a flighty buyer, right? I suspect you might have seen in your tenure in the real estate business, you know, buyers and maybe even sellers for that matter, but we're talking about a buyer, not always do the right thing, right? So let's say I'm a buyer and I am working with cooperating broker A at company A. I don't know, maybe 2-3 months, seeing a lot of homes, whatever the case may be. But at the nth hour, I go to my auntie, who is also a realtor with company B, and I have auntie write the offer. You see? Now, the PBBIC at company A, I caused trouble, didn't I? The PB at company number 1 is going to say, no, we procured that purchaser. Granted, we didn't write the offer, but as I said, right, there's no predeterminer with respect to arbitration, you know, entitlement to commission. So that broker principal could file directly against the listing broker, or if the listing broker paid Auntie's company who wrote the successful offer, then that cooperating broker can run directly to company B, chase the money as I call it, and invoke arbitration directly with the cooperating broker that was paid. I hope that answers that question.
Okay, we're good to go to the next one.
All right, super. So number 5 in the last polling question, and then we'll roll through some of these the 3 different areas that I want to talk about today. So number 5, and this deals with the ombuds process. So would you as a PBBIC want to be notified initially if the association receives a request for ombudsman intervention concerning one of your licensees? Wow, that was pretty overwhelming, right? A couple of you say no, or I'm not sure. And we're going to, the not sure is I'll explain what the ombuds process is. And by the end of today, you'll understand what this is about. But the overwhelming majority, like 94% of you said, yeah, you would want to know, you would want to be informed. And that's information that I think is important for, you know, Nani and May, Nani over Kauai and May over Maui, and Taylor and Kona, and of course Ashley and Hilo, to know and to hear that overwhelmingly in Hawaii, our broker principals want to be involved at the front end and not be surprised once an ethics complaint is ultimately filed when they are notified, right? You want to be able to triage and perhaps negotiate or see if you can fix it, the issue, whatever it might be, at the outset. So many associations do have the policy, they've adopted policy that they will inform the broker principal, you know, the PBBIC qualifying broker, you know, depending what they're called across, you know, the country, would want to be informed. So I'm sure that Ethel and Crystal will relay this to the staff execs so that they can revisit on at all of the associations, their policy with respect to involving the broker principal at the outset. Some associations do that with an ombud situation. Some associations do not. So great. I'm glad we asked that question. All right, super. So let's pivot. If there aren't any other follow-up questions on any of those 5, let's go. Let's see, let's go to the next section that I'd like to talk about, and that's arbitration. So as I mentioned, the duty to arbitrate and the privilege to invoke arbitration lives in Article 17 of the Code of Ethics, and the most common type of arbitrable issue that we see arise are these procuring cause issues. So I'm going to spend just a few minutes going over arbitration, which is the more formal of the dispute resolution processes that we're going to talk about today, and procuring cause. So there are 17 articles, and the arbitration of disputes is limited to the components or the principles that are addressed in Article 17. And so what are those? Well, right here, they're outlined, right? There has to be a contractual dispute like we were talking about, or a specific non-contractual dispute, right? Where a cooperating broker will chase the money and file directly against the cooperating broker that was paid. So there has to be a contractual dispute or a specific non-contractual dispute, and those are addressed in Standard Practice 17-4. It has to be between realtor principals associated with different firms, right? Broker principal of company A versus broker principal of company B. It has to, the third bullet, it has to arise out of their relationship as realtors. And I wanted to make the point too, as one of the polling questions did, that a client, right, can also invoke mandatory arbitration against their realtor principal. So the Uniform Arbitration Act is alive and well in almost all states, including Hawaii. It's not always so uniform, and this allows the association to issue a valid and binding and enforceable award. When I say it's not uniform from jurisdiction to jurisdiction, it is within a state, intrastate, but you know, California's Arbitration Act that allows the boards in California to render awards is different likely than Hawaii. For example, you in Hawaii have the ability to subpoena a witness in arbitration. In some jurisdictions across the country, that's not the case, but the ability to issue an award and have that award enforced is nestled in your state's Arbitration Act. So here are the factors for consideration, and this is in Appendix 2 to Part 10. Those of you that are interested in learning a little bit more about this or delving into it a little deeper, you might remember that I mentioned that an arbitration hearing panel is going to look at the entire course of events. And again, there is no predetermination with respect to entitlement. They're going to be looking at, did the person working with the buyer abandon the buyer? Did they do something or neglect to do something that made the buyer walk away from them, right? Did they do something or neglect to do something that made that buyer be estranged, right? Obviously, your awards conform or comport with state law. And, you know, from an arbitrability perspective, are we looking at broker principals, right? Or a client and a broker principal with respect to these kind of factors. So 6 factors that arbitrators will always look at. So if a licensee comes to you and says, I think that we are the procuring cause of sale, crack that Code of Ethics and Arbitration Manual or look it up online at nar.realtor and go over these factors. There's also a worksheet that will help you triage, at least intra-office, what you think your strengths are in your case, all right? So the procuring concepts are an uninterrupted series of events with no abandonment and no estrangement, right? That would be the argument for the complaining broker to make as to why they're entitled, and to suggest by a responding, a broker who's a respondent, why the complainant should not prevail in an arbitration. So here's the definition of procuring cause that's contained again in that book, Code of Ethics and Arbitration Manual. This is our definition that we live by. And the common misconceptions, and this I think was showcased in one of those first polling questions. I think it was, which one? It doesn't matter. That he or she who shows the property, that won't necessarily dictate that they are found to be the procuring cause. Same is true as far as the person that writes the contract. and the individuals who have the buyer broker agreement won't necessarily prevail either. These are all factors for consideration, but no one of them trumps the others. All right. Typically we have one procuring cost. Awards are generally not split, and in some states you can't even split them. But generally, if the amount on the table is $10,000, the award will either be rendered for $10,000 for the complainant, or the complainant will get zero. One. And this is the framework. These are some of the things that arbitration checklist in Appendix 2 to Part 10 go over, and these just highlight some of the questions or issues that are addressed in that checklist. So if you're involved in an arbitration, you might want to pull that Code of Ethics and Arbitration Manual and look over that checklist, because your arbitrators will be working off of that most likely. Also, when we were looking at the factors for consideration, keep in mind that although arbitrators do not and cannot make a determination with respect to who's entitled to what amount of money because of a violation of the code, they do have the ability to take all factors into consideration. So somebody, one of the parties, the complainant probably, might suggest that the respondent did something that was contrary to the code. Well, the arbitration chair might allow some discussion on that issue, but they will not allow that to go on because it's not relevant to the monetary issue. It's a factor to take into consideration. And that's one of the reasons why, if there's both an ethics and an arbitration that's filed, why the arbitration hearing is always held first, because we do not want any party, right, to covertly or overtly sneak the finding of an ethics hearing panel into an arbitration. So my point here with this slide, I just want to make sure that code violations aren't determined by arbitration hearing panels, but because there is a review of the entire course of events, that in an arbitration hearing, there might be some discussion with respect to unethical conduct. All right, so I just wound up with the arbitration section. Any questions in?
No questions so far.
All right, super. Let's move on now to the least formal. So arbitration is the most formal in our dispute resolution toolbox for you to avail yourself of. The least formal is an ombuds program. And you are excellent negotiators, or you wouldn't have the position that you have, right, as a broker principal. So you routinely negotiate. And this is a definition that I pulled out of the Webster's dictionary. If, though, you're not able to negotiate successfully, reasonable people can disagree. You have the ability to knock on your association's door and request an ombudsman to become involved. And here's the definition of ombudsman from Webster's. An ombudsman is someone who will assist in the communications when there is a problem to rectify that problem. Oversimplification, but that's what we work with. So in our in the realtor family, usually you're going to have a realtor that functions in that capacity. Sometimes you have a staff person, but not oftentimes will staff function as the ombuds. Usually an ombudsman will work via phone, not usually only solely via email with the disputing parties. Usually they'll pick up the phone, right? Not always, but usually it's done via the telephone, and usually by one of your peers. They are all about, that ombuds is all about assisting the disputing parties come to some resolution, enhancing communication in some form or fashion. We're trying to figure out where the breakdown in that communication came, and moving beyond the stated positions of the parties and looking at the interests of the respective parties. All right. It's always voluntary. there's no cost to you if you want to invoke ombuds, but you can't make the other party involve themselves with an ombudsman. It's a voluntary process. All associations offer it for sure. And you can request or request an ombuds to help with an ethics situation or an ombuds to assist with an arbitration situation, but it's voluntary on all individuals' behalfs. So here are lists, not comprehensive or all conclusive, but the types of disputes that can lend themselves to being worked through with someone who is an ombudsman. And I want to shine a light on this last one. You know, this is a benefit to you as a broker principal. You can use the ombuds process intra-office. If you have two licensees that are beefing, right, you can involve an ombuds if you choose to, and they agree with your association. Sometimes a third neutral. I know my kids, I think, will listen to a different adult if they hear the same thing. Then they might hear from me or my husband. You know, it's just a different lens for your licensees to hear perhaps the same information that you've been trying to get them to understand. So my point is, you can use this intra-office as well. So how it works, initially, a complainant could be either a realtor, member of the public, contacts the association, staff then puts them in touch with ombuds, right? Inquires whether or not the people would be willing to engage in the process. And if so, great. And if not, then we move forward and the staff will show them, explain to them what other options they have. So when an ombudsman gets involved, they will call the complainant typically first, listen to their concerns, of course, and decide how best to proceed. If your association has policy that you, as you know, a broker principal, will be looped into those discussions initially, you'll get a call as well. And then what are the possible resolutions? How can we close this so it doesn't ripen into a more formal ethics complaint or arbitration request, right? And ultimately that ombuds is going to destroy all their materials, of course, regardless of whether or not the ombuds process is successful or it's not, right? So that's the second bucket, the least formal. And when I say that, typically there's no meeting with the ombuds in person. That's not cast in stone, but usually those are all telephone. Mediation is a bit more formal. Any questions on ombuds, Ethel?
There's several, but there's one that came in right after you started the ombuds portion that was from the earlier one.
Okay.
I'm not sure if you have an answer to this one, but here goes. What are the most typical issues brought to mediation and arbitration in Hawaii? Would be good to know to educate our agents better. Keeping the parties confidential, would it be possible to publish arbitration summaries each year, like those found in the Realtor magazine?
So you've got a veteran member there. We do not have case interpretations for arbitrations. We have, I don't know, maybe 150 of them. And many of you broker principals know about those for ethics cases. So if you are thinking about filing a complaint or you have had an ethics complaint filed against you, know that another resource for you are the case interpretations. Mind you, those are all related, all 150 of them, so to speak, are related to ethical issues on all of the articles. Some have more case interpretations as opposed to less, you know, Realtor A versus Realtor B scenarios, right? To help broker principals like yourself and members who sit on these panels and make the decisions, properly interpret the code, right? But the reason why there are no similar grouping of arbitration is because each and every arbitration situation is the same, and those factors for consideration that I had put up, those 6 factors, will be weighed differently. There are no findings of fact in arbitration either. But having said that, what can occur in cumulative manner is, and some associations do this, they'll say, you know, 95% of the arbitrations that were filed dealt with procuring cause issues. And those are, as we were initially discussing, right? Cooperating broker A thinks they should be paid when Auntie writes the contract, in my one example, right? Cooperating broker 1 thinks they were the procuring cause. By far and away, the most common types of arbitration that we see filed across the country are procuring cause issues, not 100%, because we also see issues, for example, like what am I thinking of? Referrals, right? Referral issues, those can be arbitrated as well. As can, and this is an important benefit to you, as can those issues that bubble up in your office, in your office. In other words, if you're a broker, if you as the PBBIC have 2 licensees that both think that they were working with a buyer and should be paid, and they're both top producers, and you don't want to alienate either one of them, right? What you can do is say, hey, let's go mediate, let's go arbitrate. You can ask for an ombuds to get involved, but if the ombuds or the mediation is not successful, you have the ability to ask for arbitration, even intra office. So in response to the question, the vast majority of monetary issues that are heard by boards are well into the 90%. I would guess procuring cause, straight up procuring cause. But there are other contractual issues that, you know, are raised, like referrals, and you know, in-house disputes, and sometimes, you know, clients can file against a broker principal as well. So you've got a smattering, a couple percentage points of those other types. What you can, you can't use Realtor A versus Realtor B scenarios, right? But what you can do is publish activity reports. You know, across the state, there were, I'm just making it up, 75 cases filed in the entire state, and you can break it up by island, right? This is the amounts that were in dispute. This is the number of times a complainant prevailed. This is the number of times when they didn't, kind of deal. And you can even include whether there was a procedural review request or not, as an example. And those kind of general cumulative things can be shared, but not a case scenario, for example. And the rationale behind that, again, is there are no findings in fact, and we don't want to develop those, because we don't want someone coming in. And saying, oh, look at this case, you need to award me money. No, we're going to trust those 3 to 5 arbitrators, your peers, who are going to weigh all the factors and decide what's the most just thing to do in any one particular situation. All right.
Okay, thanks, Diane. Now on to the ombuds questions.
Mhm.
Should a record be kept at the board office regarding the situation/decision that results from the ombudsman involvement?
So associations handle this differently. I think the record should be destroyed after you compile, because I think education, and I think one of these other questions is important, right? For your PBs, BICs to know where are the problems occurring. If you publish an ethics activity report and you find across the state, you know, that the vast majority of ethics complaints are arising out of Article 2, right? Exaggeration, misrepresentation, or failure to disclose pertinent facts about the property or the transaction, then we can do some education. So to answer the question, I think the records at the association should be destroyed, but not until, right? Not until you glean out of any particular case, things that you can use to help educate your members, if that makes sense.
Okay, I think you answered this other question, how to document ombudsman decisions in writing.
Yeah, or whether you even do.
Mhm.
Sometimes in an ombudsman situation, they're not even in writing, right? People just, they don't want to put it in writing. They trust and they carry through and do what they said they're going to do. In other situations, there's no right or wrong way, right? You can, in an ombud situation, put that decision in writing, the agreement between the parties. I'm a fan of doing that, but I understand that's another step just to ensure that there is no miscommunication. One of the things that I want to make sure that you understand, though, as PBs and BICs, is that you can delegate your authority to agree in a non-buds or in a mediation situation to a non-principal who you trust with respect to the particular settlement, be it either in the ombuds or in the mediation arena. You do not have the ability to do that in arbitration.
Okay, great. It says, what is next option if defendant, in parentheses, person accused, not participate?
Can you read that again?
Yeah, I'm not clear what is next option if defendant, and in parentheses, it says person accused, not participate.
So I don't know if I'm answering the question depending on what that is, but I think most boards in Hawaii are option 3 boards. And when I say that, you can proceed in the absence of a respondent in an arbitration situation and render a valid and enforceable award. Check with your staff administrators, but I believe most, if not all, boards have chosen that option. So those individuals who just don't show up as a respondent are doing themselves a disservice because they're not in any way, shape, or form going to stymie the process. Now, they use the word defendant. So if there is something filed in court, exercise your right as a broker. You PBs and BICs, if somebody hauls you into court, if another broker principal hauls you into court, file the arbitration, right? The board won't know about it until you invoke arbitration, and they can't take jurisdiction over that arbitration and get it out of the court until you make them aware of it. Once the grievance committee retains jurisdiction of that arbitration and refers it on a mandatory basis, then that defendant in the litigation can extricate themselves from that litigation, most likely by going to the judge and having that judge kick it out of. They don't want that. The judge they don't want that stuff clogging up their docket. They're more than happy to kick something out from a situation where there's litigation pending.
Okay, great. And there are just several questions about getting a replay, a recording, and then about the slide deck. So I just want to remind everybody that they will be receiving a recording as well as a copy of the slide deck.
Super.
And
Yeah, you could
that's
use it, maybe
Mhm.
portions of it at least, to share with your non-principals, your licensees. So let's wind up talking a little bit about mediation, and I do want to get to those tips too. I think that those are probably pretty important. So mediation is a bit more formal than ombuds. Still a voluntary process, and you've got a neutral who's helping with the communication between two or more parties, right? So it is not, though, discovery for an inevitable arbitration. And it's important that you help your licensees understand too that an ombuds and a mediator, they're not going to be telling the parties what to do, right? The decisions and the flexibility of both of those are totally up to the parties. And that's the beauty of those ombuds and the mediation, right? It's the disputants themselves, the parties, not the mediator, not the ombuds, who are the parties are going to be making their decision and the resolution and making the decision as to whether or not it's going to be verbal or put it in writing. So it is a voluntary process, although a minority of boards have, by virtue of action by their board of directors, classified mediation of mandatory arbitration situations as outlined in section 44 of that Code of Ethics and Arbitration Manual. Some associations have mandated mediation. It requires a change to the board bylaws, but some associations have done that. Again, the parties in most instances, if your association hasn't mandated mediation, they decide whether or not they're going to be entering in to those discussions, and they can leave the process at any time, and they decide the outcome, not the mediator. It is a neutral person, both the ombuds and a mediator. They're neutrals. They're not going to get involved if they've got a conflict of interest, right? You can even pull, because I know that Hawaii has, with all of the associations, a cooperative enforcement agreement. If you don't want to use a mediator or an ombuds on island, right? You know, if you're in Kauai and you don't want to use, you know, a mediator or an ombuds there, you know, you can ask your staff administrator to pull somebody in from Maui, you know, or the Big Island, right, to function in that capacity. Your cooperative agreement, your statewide cooperative agreement is robust, and you've done a good job in drafting that. And that mediator is going to stay in their lane. They are not going to either write the decision, because it's not very, we want the parties to make the decision. They're going to decide whether they settle and how that settlement agreement is going to look. Both ombuds and mediation are confidential, right? And these are the benefits, right? Who wants to spend in the more formal arbitration process 3 to 6 months out of your life? You want your licensees and you want your attention to be on moving forward, right? Serving your clients and customers, not looking retroactively, back improving your case in a more formal arbitration. Now, mediation and ombuds don't always work, and sometimes we will end up in an arbitration, or perhaps you don't even choose to go with mediation or arbitration, but mediation works because you can usually set up a mediation in a week or two, depending on the party's, you know, availability. And it has the added benefit of improving relationships. I personally have never seen a situation, and I was there 5 years as the professional standards administrator and about a year as the MLS director. I have never seen the parties walk out with a better relationship in an arbitration situation, whereas I have seen it on numerous occasions in a mediation situation, right? You know, they're grateful that they're able to move forward. It's a small, you know, real estate, especially in Hawaii, you know, there's a small number of you professionals, and it's always better if you're able to work out those differences. Not always possible, but it has the ability to improve, at least maintain relationships. And the other issue in arbitration, you have no power other than arguing your case. Where here, you have the ultimate power and lots of flexibility to settle the dispute as you choose. Maybe somebody just needs an apology. It's not always about money, something along those lines. So a lot of flexibility in the mediation, a lot of ability to do those creative solutions and save yourself, your client, if they're involved, and the other broker. It's a win-win for both of them. And it's a win-win-win for the association too, because they're not using association resources to process the more formal arbitration. All right. There are some pros and cons with respect to providing mediation remotely, and we'll talk about that on the next slide. But I think given us coming out of the COVID, you know, 2-year hiatus where we were doing everything electronically via Zoom, I think still yet we have, and I think it's here to stay, some ability to mediate remotely. I do think that, especially in some states, it works beautifully. For example, Wyoming, right? Lots of well, same on neighbor islands, right? So you could do a mediation remotely too. It doesn't have to be in person. There can be technology issues. I'm sure all of you have had those, not in this area of association management, but in your businesses. and you don't know who's on the other side of the camera either, right? With remote situations. And it's not in a situation like this. I mean, I would love to see everyone's faces and be in the same room. There's a way to build rapport, and that's important in a mediation, for a mediator to build that rapport. And that's much more difficult to do with a little box when you're looking at someone's face, right? There's a lot of our communication that stems out of or is because of body language, and electronically. Here we're on Zoom today. You're not able to pick that kind of communication up. So here, this compares mediation and arbitration. Both are private, trained neutrals. Mediation is cheaper typically than arbitration. There can be an arbitration fee of up to $500 per party. Mediation, typically there is no cost, and oftentimes if there is a cost, it's refunded if there's a settlement. And certainly, as we said, mediation is much faster. But unlike arbitration, the big difference between mediation and arbitration is that you will get a final decision in an arbitration, whereas you don't necessarily have that closure in a mediation. And here's kind of an overview, and I'm just going to spend just a few minutes, not on this slide, but on the common, I wouldn't want to say mistakes, but things that I want you as broker principals, if you could just stay on just another minute or two to go over to make sure that you catch that. If not, please watch the end of the webinar. Sorry to have gone over just a few minutes. This is kind of a cool overview that compares the ombuds, mediation, and the arbitration, what we've been talking about this afternoon. And you'll see here on this, what is it, fifth box, where the definite closure comes in an arbitration. You will get an award regardless. You won't have any control over the decision like you absolutely have control over in the ombuds and the mediation situations, but take a look at this at your leisure. Now, I want to share some best practices with you, and there's just 4 of them. So you as a PBBIC are going to be involved in an arbitration. Make sure your licensees understand that if they're a realtor and they've got a monetary interest in the outcome, they can remain throughout the entire hearing at your discretion. Most broker principals will want their licensee there with them from start to finish, but they are not the party. They're not the one driving the bus. You are. No ability to delegate in an arbitration situation. You are the broker. Not the, I see when paperwork is filed, you might say to your licensee, well, write it up. Well, they take that, they misunderstand. They submit it to the association, right? Make sure that you're clear. You write up the facts, let me review it. I'll decide if I sign my name to this and become the party. And I made this point, the second bullet, know that your association is there to help you settle intra-office disputes. All right. Name your company and the respondent's company, right? We're going to have a realtor principal as a complainant and a realtor principal as a respondent, but name your company as a co-complainant and name the respondent's company as a co-respondent. If you prevail, and let's say the respondent realtor principal goes off to Tahiti or something, or, passes away or whatever the case may be, you can still have that award enforced if the company is named, right? So best practice or things to keep top of mind is when you invoke arbitration, name your company, same with the respondent. Oh, this is one of the common mistakes that I've seen made. Okay, this last bullet, and then we'll conclude for the day. Sorry, we weren't able to get to the questions on this one, or maybe we will, right, Ethel? Because that way they'll be there recorded, right, for later. On this last bullet, one of the things that let's say I was with Realtor A, and for whatever reason we had a falling out, and I'm no longer affiliated with Realtor A's company. I go to Realtor B, I hang my license with Realtor B, and I explain to Realtor B what wicked person Realtor A is and how they didn't, live up to their independent contractor agreement with me. What I see, this is common, is that new broker principal, if they believe, right, I convince them that I've been quote unquote mistreated, they'll file the arbitration themselves against the realtor principal that I was previously affiliated with, not arbitral, right? There's no contractual basis upon which to render that award. Realtor principal number one never agreed to pay realtor principal two any money. The redress, if somebody comes to you and asks you to do this, what you do is you inform, you can give them to, your professional standards administrator at the local board. But the fix here is that you say, no, I can't invoke arbitration. I support you, but I'm not the party. You have the independent contractor agreement. You can invoke arbitration with your prior broker. Now, mind you, it's always voluntary, or the prior broker can request arbitration with the licensee as well. But again, that's voluntary. But don't get sucked into a situation where you're going to waste time and your energy and frankly the resources of the association. I wouldn't say waste, but use the resources of the association, because the grievance committee on this last bullet will dismiss in every instance. They're not making a statement that the licensee has been treated fairly. They're just simply saying, look, there's no basis to support the award. There's no contractual basis to support that award. So those are the top of mind issues that I wanted to cover. And Ethel, I know a lot of brokers had to jump. I know you've got other issues, but Ethel, I'm more than happy to answer any questions that that you have outstanding, so that the recording, the people that want to listen to the recording have those answered for them.
Sure. There are several questions. So if whoever needs to jump off, then they certainly can jump off, but at least these will be in the recording. A question is, what's the time frame in which to file for any ombuds, mediation, or arbitration?
So mediation and ombuds are very flexible. You can provide those services outside the 180-day window, but in section 20A for ethics, and in section, my manual is right here, for arbitration, it is section 47 on page 148 of the manual for arbitration. Those formal ethics and formal arbitration, there is no flexibility. There's only 180 days. That time frame is 180 days. In section 20A for ethics, it's 180 days from the time the complainant knew or could have known in the exercise of reasonable diligence of the problem or the conclusion of the transaction, whichever is later. That's the standard in ethics. And in arbitration, it's 180 days after the closing of the transaction, or within 180 days after the facts constituting the arbitrable matter could have been known in the exercise of reasonable diligence, whichever is later.
Okay, there's the next one. Mediation decisions cannot be used at arbitration.
Correct. Your chair and those administrators that review this or are on the call, it's important that you set expectations. So when you're sending out your notice of hearing in an arbitration, for example, and the parties weren't able to settle in with an ombuds or with a mediator, make sure you remind them that issues of settlement or information that they became privy to that isn't discoverable outside the mediation, that only arose in the mediation, are not applicable or able to be submitted in, let's say, for example, in an arbitration or in an ethics hearing for that matter. Your chair of your ethics hearing panel or your arbitration hearing panel will not allow offers of settlement to leak into and try to, the character and the reputation of someone typically has no bearing on the merits of a case. So somebody might want to use the, look, I tried to be reasonable. I offered that. Cheryl, stop that conversation in a New York minute.
Okay, I think you might have answered this one. What is the typical cost for mediation and arbitration?
So no typical. I can tell you, I know of one association, maybe two, that has no cost. It's built right into their dues, no cost for arbitration or mediation. It is very typical, though, for there to be a cost for both parties in an arbitration. The association cannot charge any more than $500 per person in an arbitration. They oftentimes will charge less, like $250 or something, but because these are expensive processes and sometimes we have to get counsel involved, many associations max out, and still it's a bargain, right? If you have to defend yourself or invoke litigation, a lot more expensive than $500. So still a pretty economical service. Many associations you cannot charge for ombuds process. There can be a charge for mediation, but cumulatively for all dispute resolution, it cannot go more than $500 per party. So maybe they have a $250 for mediation requirement for a monetary issue. And if that doesn't settle, they could charge the party another $250, right, for arbitration. Because total, right, $500 max, that would be fine. Many associations have policy, though. Let's say, for example, if they do charge a nominal amount like $250 for the mediation, they will refund those monies, if there's a successful, if the mediation is successful. It just incentivizes the parties, right, to settle. They get their money back. That's not policy, but that's common, I think, very common.
Thanks, Diane. The next question, all of our legal assistance is with broker to broker. What do we have for assistance when a seller commits a tort against us as a listing agent?
Yeah, I know. Somebody once told me buyers are liars and sellers never tell the truth. Your party, and it doesn't matter if you're working with a buyer or if you're working with a seller, right? They don't always act well. And I would imagine in some instances, you've even stepped away from a potential listing, seller, for example. Nope, I know from experience, it's not worth it, right? And just step away from the outset. But you may be in that contract, right? And have that seller be doing things that are inappropriate. And I would defer to your counsel as to, depending on what the specifics are, what your options are with respect to that contract. Would it enable you to break that contract, right? Would you have redress or recourse in the courts? Not that it's typical for a listing broker to quote unquote sue their seller, but you would triage that. Best advice I could give you. I know we don't necessarily, and I apologize to anybody who's also an attorney on the call, but best advice I'd have would be to get next to your counsel and let them know what the specifics are so they can best advise you as to what your rights and responsibilities would be, and how to minimize any disruption that seller has caused.
Okay, next question. What is the time frame someone can go after the broker or buyer if that's the case for breaking a buyer-client purchase agreement?
So, to quote unquote go after, so if someone, for example, let's say I'm a realtor and I've got a buyer broker agreement and somebody else interferes with my agreement, I can file an Article 16 allocation against that other broker who meddled, right, and caused that agreement to dissolve. But if we're talking about, and that would have to be filed within that 180-day window with respect to Section 20A of the manual. With respect to pursuing something in the courts, given your buyer broker agreement, because you certainly can do that, right? Listing brokers can sue their sellers and vice versa. Buyer brokers can sue their buyers. Again, I defer to your counsel, depending on what the situation is, as to what window you have to bring litigation. if
Okay,
that's what you determine to do.
thanks, Diane. This is a FYI. The Honolulu Board of Realtors mediation is free and no charge.
Cool. I think that's typical. I think it's not as typical for an association to charge for mediation. It is exceedingly typical for arbitration to carry a fee. I only know of for sure one, maybe two associations that don't charge a fee in arbitration. But that is rare indeed. And you don't usually get your money back either as a complainant, even if you prevail, or as a respondent in arbitration.
And that's it for the questions.
Cool deal. Cool deal. And then Crystal, and Ethel, thank you. And thank you again. Remember, those of you that were able to stay with us and who view this later, you're local, your state association who brought this to you today. And here at the National Association, we put you first. We're here to serve you. We're here because of you. And we're committed to empowering you to and help elevate you as a member, and so that you are the most successful and you work as efficiently and effectively as you can in your important role as a PBBIC. So thanks for having me, you guys. Had a wonderful time. Crystal and Ethel, I've got 4 case scenarios that we didn't get to today that are attached to this. And I think with what I've worked through, the individuals who want to look at those last 3 or 4 slides that have, I think there are 4 of them. The question that you're being asked is it arbitrable? And if so, is the arbitration, should it be classified as mandatory or voluntary? I think I've provided you enough information here so that you can answer that as a PBBIC. But I'll give Crystal and Ethel and Wendy the answers to those. Don't just ask them for the answers though. Read through those last 4 slides and you decide, work through that, and you decide whether or not you think it is arbitrable, if there is a basis upon which to render a monetary award, and if so, if you think the arbitration would be mandatory or voluntary. All right.
Thank you so much, Diane. We appreciate your time. Hey, virtual hand clap for Diane. And just a reminder before we sign off that we do have an evaluation for you to take a few minutes to give out your input on the session. So go ahead and do that as soon as we sign off. I will work really hard to try to get the recording out this afternoon. If not, it'll be out by tomorrow as well. Thank you, Diane. Aloha.
Aloha,
miss
friends.
you. Come home sometime.
I know. All right.
Thanks,
You guys have a
Diane.
wonderful day. Bye now.
Bye.